Please be seated. This is the matter of Clarence Moriwaki versus Richard Rynearson, cause number 12-17. We are here for a full order hearing, and I have had a chance to review all of the materials that have been submitted here, including the 2 large binders that were filed by the respondent. Did you receive copies of those in the mail,
yes,
Mr.
I did.
Moriwaki? All right. And so typically we might have testimony at a hearing like this, but we typically don't have such a complete written record as we do here. So I wanted to find out from the parties what you anticipated in terms of any presentation of additional testimony or evidence here today, or if you just wanted to make some legal argument and go forward on the briefs. Mr. Moriwaki?
I would just move forward on the evidence that's been already submitted before us.
Okay. And from defense?
And that was our plan as well, Your Honor.
Okay. And so the people who are gathered here didn't intend to testify, or they're just here as observers?
If they wish to, I didn't ask any.
Okay.
But I don't think that's necessary.
All right. Well, I have had a chance to review everything in great detail. I have read the 2 large binders. I've reviewed all of the previously submitted documents here and spent a great deal of time with all of the information that is here. So if you would like to, Mr. Moriwaki, make any sort of argument to the court, I will hear you now.
Yeah. Well, first of all, I'll thank you again, Your Honor, for having the hearing. Most of the new evidence that has been presented is similar to the same information that's being presented by the respondent to federal district court, and that's the appropriate venue. If I can just pass these out to the counsel, and you know what the court is, of course.
Okay. And what is this you're handing forward?
Well, what I'm pointing out on the first page is what the municipal court under RCW Chapter 3.50 does, and of course you know that better than I. This is what your venue is. So the issues of constitutionality, of public figure, of First Amendment, 14th Amendment issues are not purview of this court, nor should be considered in this court, and that is by the respondent's own counsel. Attached on the next pages before, you'll see just a few pages of the brief that was filed by his counsel. I only printed out a few pages because we have more than enough pages here today. And on page, I can't tell what page it is, but the second one in the packet right below it, underneath jurisdiction and venue, the respondent's counsel starts out by saying, jurisdiction is properly vested in this court, in this case the federal district court, pursuant to USC, blah, blah, blah. This case presents federal questions. And I agree with the counsel, his counsel on that. It might be surprised, but their counsel is deciding to go into a federal court to discuss issues of First Amendment and also of public figure and all the rest that most of this brief is pertaining to. So those arguments that are in here I don't think are applicable to this court. This court does not have the jurisdiction under statute to address these issues, and the respondent's own counsel has put it into federal district court to have those issues heard. So I think the arguments brought in here are not appropriate, but in the wrong venue, so therefore should not be considered during these proceedings.
Okay. Any other argument?
Other than a couple other things, these issues are not. You already made a temporary protection order. I think that was the right decision. I would also say that the only thing that we learned since our last meeting was that respondent lied about how many weapons he had. We learned that in this court, that he said under your direction that I believe you asked him how many weapons are you going to surrender. The respondent said there were 4. Then there was like a 1.5-minute consultation with his counsel, and then after that he said there were only 4, but 2 belonged to his wife, or registered to his wife, I believe the words were. And you had said, doesn't matter, it's in the home. A few hours later, we found out that there were more than twice that many that his wife brought to the police department, I believe. And so the truthfulness of what has moved forward is really in question. And that is the only new fact in this case that has come up since the last hearing. And it frightens the death out of me. And it should frighten this community, because he's withheld that from you, he withheld it from me, and he withheld it from our community. And we don't know if that's true. We don't know if there's even more. I also read in the man's brief that he's been traveling, and it makes me wonder where has he gone, and not for where he's gone, but what he might be doing. That because of our laws, they're so lax, and they're even more lax in other states, how do we know other weapons haven't been acquired? We just don't know. The truthfulness is in question. And finally, I'd like to add this from that court hearing, or the
All right, you can fast stamp that one.
statement that this is a news report, this is the Associated Press report, this has been carried around the country. I'd like to draw your attention to the very last paragraph in this article, and he is Mr. Rynearson, and I'll read it. He took the page down, that page about me, from your temporary order, and ceased proceeding to criticize me. In response to the temporary protection order, he said in that declaration, but he, Rynearson, would like to resume the online criticism. He intends to continue the online harassment. And I recall your orders to him at the end of the last hearing. I believe you were speaking to counsel that said, and I'm paraphrasing, but perhaps it was, I don't think your client gets it, that I wish to be left alone. And here he is in the press saying, I'm trying to do this and get this case overturned because he wants to continue to harass me. He says it right here in the public record, right here in the newspaper. He isn't getting it. That's why this permanent protection order has to be given. He's proven his untrustworthiness. He's already proven his intent to continue the stalking and harassment. I need some relief. I've really had nightmares over this. It's been very grueling and very difficult in myself, personal relationships, and other issues. So I just need relief on this. I need a permanent protection order. The surrender of a weapon should be permanent as well, and you should not release his concealed weapons permit.
Right, thank you. Right from respondent.
Thank you, Your Honor. First, to just very briefly respond to the petitioner's remarks regarding the federal case. The federal case is completely separate from this one, so I don't think I really need to touch upon that too in depth, but the petitioner's belief that this court cannot address and determine whether certain speech that falls under the allegations are First Amendment, things of that nature, that's completely untrue and incorrect. If we look at the definition of course of conduct, which is obviously a key component to this statute, the harassment statute, it explicitly states in the definition that First Amendment speech, constitutional protected speech, does not count, is not to be considered when determining whether harassment has taken place. So it would really tie the court's hands if the court was not able to actually make that determination. So that argument falls flat. Moving on a little bit, the petitioner is interchanging criticism with harassment, and that's not accurate. That's not true. To criticize an individual and to disagree with them is not harassment. And this goes into the heart of the Constitution and First Amendment. We're talking about a country that wants us to disagree. We want to disagree with people in power, whether it be politicians, other government officials, or other public figures. That is the heart of trying to make sure that there are checks and balances. And so to perceive any type of criticism or second guessing as harassment, that's just a very slippery slope, and it's frankly just not true. Now, moving on, let's talk about initially what this case is not about, because it's going to help us focus a little bit more on what this case actually is about. First of all, it's not about obscenity, it's not about defamation or fighting words, there's no vulgar or salacious speech, there's no lewd, lascivious, indecent, or obscene words or images, and most importantly, there are no threats here. Now, it's unclear to me whether the petitioner is still proceeding on his accusation of physical stalking, but he should know that this is absolutely untrue. The only thing that he points to as proof of his physical stalking claim is the analogy of his own creation, his party analogy, which the respondent just simply continued. So if he looks at the statement, he knows it's not a true statement, it's an analogy, because otherwise, did he have a party where the respondent was at? No. Was the respondent at this make-believe party saying things that he disagreed with? No. At some point, did the petitioner place his hands over the respondent's mouth? No. And did he throw my client outside of this party? No, none of this happened. And so the last step of that analogy is my client standing outside of his house talking to passerbys. Well, if 1, 2, 3, 4, and 5 are clearly not true because it's an analogy, you would think the last one is as well, when it's all the same thought line of thinking. And to jump to that conclusion where you can conveniently ignore the first 5 and then focus on the 6th one as this must be proof, that's not genuine. Now, moving on, let's talk about whether the specific physical acts are harassment. Now, I'm not talking about content here. I'm talking about the physical acts themselves. So, for example, he's not showing up at the respondent's house pounding on his door. He's not standing outside his house with a big bullhorn waking up the neighborhood. He's not ringing Mr. Moriwaki's phone at all hours of the night, constantly forcing him to interrupt his peaceful rest in his home. Nothing like that's happening here. We're talking about content. We're not talking about actual behavior itself. We're talking about the content of it. And lastly, we're not talking about, while it's immaterial, we're also not talking about anonymous contact here. Every single Facebook post from my client has his first name, has his middle name, and his actual photo right next to it. So he's not hiding from anything here. If you go to his Facebook page that all these posts link to, it has photographs of his last name as well. So anyone who does 3 seconds of clicking will see exactly who this individual is. There's no anonymous communication. And even then, the First Amendment still applies to anonymous contact as well. And we can look at U.S. Supreme Court cases, Talley v. California and McIntyre v. Ohio Elections Commission. Both of those cases say anonymous First Amendment speech is still covered by the First Amendment. It doesn't disappear when it's anonymous. Because there's obviously a lot of reasons why somebody would want it to be anonymous as well, but we're not going to go down that rabbit hole. So those are things that this case is not about. So what is this case about? As I alluded to before, it's about content. It's about what was actually being said. Because let's not kid ourselves. If my client was complimentary and just another constituent in the echo chamber saying, rah, 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 this is right, this is great job, great job, great job, we wouldn't be here. This would never have been an issue. Instead, the issue is my client disagrees with the petitioner's position and the things that he has done and has not done as a part of him being the face of the memorial. That's the crux of this issue here. This is a First Amendment case. Despite his objections to that and saying it's not, it is. Mr. Moriwaki is a public figure. Now, we're not talking about Donald Trump's size, but the court and the law recognizes there's going to be a spectrum of public figures here. The petitioner has willingly and knowingly sought out attention from the media. He's written articles, numerous articles. He's admitted to that. It's on his LinkedIn page. We've cited that. We've provided numerous articles that he's written. We've provided numerous articles that he's quoted in, that he's given statements to. He's done audio blogs. He's been the public figure and the head speaker at several, and I'm probably underselling how many events associated with not only the Japanese American Bainbridge Island Association, but more specifically, the memorial itself. He, for all intents and purposes, is the public figure for the memorial, which is part of the national park system, and its motto is about to not let happen again the evilness of what transpired during World War II by the hands of the government. Because let's not kid ourselves. Everything that the government did, that was done under the guise of law and order, safety, protection. Well, everyone in this courtroom who's been paying attention will hear that that is going on now as well. People are talking about that when it comes to terrorism and people preventing others from coming in, et cetera, et cetera, et cetera. This is an ongoing hot button topic. It's an issue. It's not simply relegated to the past. It's still now. This is an important public issue. It warrants communication. It warrants discussion. He's taken the position that he's going to be a vocal leader in the community talking about this. He has discussed the memorial and the lessons from the past and what they can be used for the present. Those are in his articles. We have submitted articles that he's quoted regarding that. These statements from my client have been in a public forum, online, internet. That is about as public as you're going to be able to get. You can reach out to everyone. Public forum about a public issue with a public figure. That is what the First Amendment is about, to allow that communication and that argument. That's what the First Amendment's about. It doesn't matter if there's any ulterior motive. And for all intents and purposes, there's been no presentation to show that there is an ulterior motive. This has been something that my client has been rallying about well before he ever met the petitioner. This is something that a lot of people, not just him, feel strongly about. And the way that the petitioner tries to cast my client as some right-wing nut job, bringing in a whole bunch of stuff from the past, it's not relevant, nor is it accurate. We're talking about legislation, federal legislation, and we're talking about state legislation that we're discussing these issues here. Again, that is a public issue right here. And so the fact that my client chooses to bring up his disagreement with the petitioner and how he doesn't do his job as the spokesperson for the memorial is somehow harassment is ludicrous. It's not accurate because my client believes the petitioner has a responsibility as the spokesman in the face of the memorial to place the interests and the goals of the memorial before his own personal political beliefs. Whether that is what everyone else agrees, so be it. But the point being is, it's a valid and it's a protected opinion. And he can say that. He can tell that to the community. He has a right to do that. The petitioner cannot avail himself of all the benefits of the media and talking publicly and try to get all the accolades, but the second somebody disagrees with him and criticizes him and says, hey, hold up here, I don't think you're doing your job, suddenly that's harassment? No, you have to take the good with the bad. That's the reality of it. He can snicker all that he wants, but that's the truth. Now, he's brought up, as I mentioned, things from my client's past, such as the fact that he disregarded and specifically rejected an order from his military leader to violate the rights of a U.S. citizen. Now, the petitioner makes a whole big stink about the number of guns and how this is being somehow not honest with the court. Well, let's talk about how the petitioner has not been truthful and has not been properly forthcoming with the court. he hammers on the fact that my client rejected an order from his superior and somehow tries to cast this as an indication that my client is untrustworthy, is dangerous, doesn't listen to authority, and is a concern. And he conveniently leaves out the part where my client ultimately was vindicated by the chain of command, and he was right, and he was fully reinstated. And so not only is this an improper argument by him, but it's also misleading, and I find that really inappropriate. And I also find it galling that an individual who's representing the memorial would take issue with what my client did, because that goes to the heart of the memorial as well. People on the ground with their boots on the ground saying, no, that is not a proper order. I refused. That is proper citizenship. That's what we wish people in the military did during World War II. And to somehow claim that what my client did and ultimately was vindicated for is a terrible thing goes against the moral compass of the memorial. And this goes to the heart of what my client takes issue with the petitioner, that he can willingly take all the benefits and he can conveniently push out and ignore all the things that are negative to him, and he can call criticism harassment. He can leave out pertinent points to the court that give the full story, and he tries to paint my client as some dangerous lunatic. Let's be honest, that's what he's trying to do here. He has no criminal history. He has a full, distinguished career in the military. He was discharged with honors. And yes, he has firearms. And every single one of them is legal. His wife has firearms. And every single one of them is legal. That is a right that we have in this country still. So for him to criticize that, he can have his own opinions on whether firearms are necessary, etc. That's fine. To each his own. But for him to criticize my client using his constitutional rights, that is not appropriate. That is not somebody using their rights as somehow being a bad thing. Again, that is going against the heart of what's at issue here. We have a right and we have an obligation to stand up and disagree. That's what the First Amendment is about, and that's what good citizenship is. And the petitioner may disagree with my client, and he might not want to talk to him, and that's fine. When he said, "No, we're posting on my board, you're blocked," my client never posted again. He never tried to do an end around. He never posted under a different name. Nothing like that ever happened. When he said, "Don't text me, don't call me," he said, "Okay, I understand. I won't contact you again. Have a good breakfast." End of story. That was a month before this case was even filed. Nothing happened here. Instead, what happened was my client posting on a public forum on Facebook, his own personal message board, and talking about his position, his politics, his disagreement. No threats, no indecent, vulgar speech, no threats, nothing of the sort. No defamation, nothing like that. Simply listing his opinion that the 2012 National Defense Authorization Act does, unfortunately, give the federal government the authority to indefinitely detain U.S. citizens. And it would make sense that who the community considers the key speaker on this topic to actually take a position on it, to criticize the legislature, to criticize the government who put this law into place. This is not some right-wing craziness. This is, and even if it was, it's still protected. But this is so normal that the Washington State Legislature actually created Senate Bill 5176 specifically to combat the NDAA of 2012. That's how mainstream this belief is. Now, we've submitted a lot of documents, and I apologize for that, Your Honor. I truly do. That's abnormal. But the reality is, the petitioner opened the door to a lot of tangents that unfortunately, we just could not let those things slide. We had to address them. And so, again, I apologize for that, Your Honor. But I want to point out here that the petitioner here has not pointed to anything in black and white here. Has not pointed to any threats. Has not pointed to anything like that showing that there has been non-protected speech occurring here, that there's been actual harassment. Instead, it's just simply a lot of political speech, a lot of catchphrases and hot-button words. But if we actually look at what happened here, it's all here. It's all black and white. It's all before the court. Every single thing. And you will not find a threat in here. You will not find defamation. You will find repeated positions from my client disagreeing with him. Yes, we'll freely admit that. But whether he states it 1 time or 10 times or 50 times, protected speech is still protected. It is what it is. So it doesn't, simply because he's made his point 1 time, that's okay, but then the 10th time is no longer okay? That's not how the Constitution and freedom of speech works. What's protected is protected. He has the right to his peace and quiet in his house. Yes. He says, leave me alone. He's left him alone. He hasn't been calling him. He hasn't been texting him. He hasn't been sending him emails. He hasn't been sending him letters. Nothing like this is happening. That said, my client doesn't have an obligation to allow the petitioner to remain in his little bubble. Each individual has the responsibility, their own responsibility, to avert their own eyes when there's something out there that they disagree with, if they don't like hearing. If somebody says something bad about me online, I don't like it. Yeah, I can understand that. But they have their opinions. They have their right to say that. I can choose just simply not to go to that website that says things about me that I don't like. As long as they're not threatening me, as long as they're not defaming me, they have a right to do that. This is protected speech here. And it's even more protected because of who the petitioner is and because of the topics at hand here. This is the pinnacle of freedom of speech. Public figure, public forum, public interest topic. That's about as protected as you're going to be able to get. I did also want to point out one last brief thing, Your Honor. And the text messages, which again, were what, 4, 5 text messages within a 2-minute period? Again, that phone number was given to my client by the petitioner. He identified himself when asked. And most importantly, that's also protected by the First Amendment. If you see the first text message, it says, I have a blog. I'm writing about this. Would you like to provide a response or a quote? There is no official badge that a media member gets. There's no media member license. That's one of the wonderful things about this country, where any individual can write about a topic. Any individual can investigate a topic and can convey what they've investigated and discovered. And they say online. My client, right there, is acting, for lack of a better word, like a media member. That's protected. And when the petitioner said, don't contact me again, done. Not again. Never again. And that's fine. Offered him to provide a rebuttal, something that my client was asking for when they were communicating on his message, where you have a dialogue back and forth. Let's have a dialogue back and forth. And it was just basically one-sided. There's no common ground, sit down, where we chit-chat. We'd see if we can try to meet in the middle. No, instead, it's basically repeatedly saying, you're not taking my position. We don't want you here. That's his prerogative. He can do that. That's fine. It's not what makes this country great. It's not what creates that higher learning. But as he said in his analogy, his party, his rules. He can do whatever he wants. My client took his party to his own venue, and he can do whatever he wants in his own venue as long as it complies with those specific rules, and those specific rules were met. No threats, no defamation, no fighting words, nothing like that at all. It was simply about a public talk, public issue, a public forum about a public figure. And all the criticism about the petitioner was only about his public figure persona. We're not talking about private things. We're not talking about his private life, whether his wife, his children. I have no idea if he has any of these things. And that was never even a topic mentioned, because that is not his public persona. That was never discussed. That's not the focal point of what was being written. And what was being written was always polite as well. So it was yes, no, thank you for commenting. It doesn't have to be, but it was. And for the petitioner to take the opinion that all of this peripheral stuff that actually has nothing to do with this case, the history of my client being in the military, owning firearms legally, somehow makes him a danger, we need to focus on what this case is actually about. And that's right here, all those text messages and the content. That is the heart of this case here. And as I mentioned before, when determining whether there's harassment, we need to look at the course of conduct. Well, under the definition of course of conduct, and I will state it again, this does not include constitutionally protected speech. And that's specifically said in RCW 1014-020. I have nothing further, Your Honor.
Okay, thank you. All right, any response?
Yeah, a lot to unpack there, Your Honor, especially that last point. He quoted, bringing up a bunch of stuff from the past is not relevant, and one of the quotes he just said is leaving out that I am deliberately leaving out pertinent points to the court. Everything he just did, he cherry-picked all of the stuff from the past. You've read the briefs. You've read the reason why I brought up these issues is he's proven that he is a serial cyberstalker. It's not about speech. It's about his behavior, and he's right, it's about content. He has a proven record of doing this. I pointed out, I don't have to go through it all over for you, but for his sake, he has been doing this to other blog sites for years. Many blog sites that have 1 million views. He's the first person they've ever blocked. One blog site in particular, John Q. Public, 45,000 likes on the Facebook page. He first person to block, and guess what he did? 14 hours later, he started a Facebook page with that person's name on it, attacking him. Exactly what he did to me. This is a habitual, consistent pattern. It's pathological. And I love how counsel always talks about he didn't say anything lewd or obscene. Well, of course, that's only part of the cyberstalking law, as you know. RCW 91.6.260, cyberstalking point 1. A person is guilty of cyberstalking if he or she, with the intent to harass, intimidate, torment, or embarrass any other person under any circumstances not constituting telephone harassment, makes an electronic communication to such other person or third party. Point B, anonymously or repeatedly whether or not a conversation occurs. He did that. Cyberstalking does not have to be insulting, does not have to be swearing, does not have to have obscene words or be indecent, as the statute reads, and he did that to me. And that's clearly in my statement on March 10th and in my April statement as well. And this court made the correct decision to grant a temporary protection order on those grounds alone. Nothing has changed to change those facts that are in this record. The public figure thing is just ludicrous. I'm going to pass to you what the current statute, the definition of public figure, according to Webster's Dictionary of Law, and it says a limited public purpose figure is, quote, a person who voluntarily and prominently participates in a public controversy for the purposes of influence and outcome, etc. If anything, right now, Mr. Rynearson is the public figure, for he has gone to the press with his lawsuit. He's the one. I did not voluntarily do this. And by the way, just because you're in a newspaper doesn't mean you're a public figure. I mean, does that mean, if you take it to its extreme, that a kid in little leagues report in the newspaper is a public figure? Of course that's not it. I'm a private citizen. And even public figures, now let's assume that. I'll give counsel that. Let's just take this for sense of argument, because he keeps bringing it up. Public figures are also protected from harassment. You could be the highest elected official, a president, Obama, Bush's, Clinton. They become private citizens. Even top name celebrities, public figures are not just elected officials. They can be noted sports celebrities or movie stars or musicians. But the one name people like Oprah or Beyonce, we know them by one name. They're so damn famous. But even they get protection from cyberstalking. Even they get protection from harassment. They're private citizens. I'm a private citizen. That argument is just so fallacious. It's grasping at straws from the respondent. And it's really wasting the court's case. And he keeps bringing up, he really lied about so many things. And it is wrong that it was an anonymous contact. Richard Lee is not his name. His real name is Richard Lee Rynearson III. I did not discover that until I started blocking him. And you can go through the first attempt. By the way, he keeps talking about free speech. Facebook is not a free speech forum. It is not. It, by definition, is a social media forum. And you can block anybody you want. You know, there's people I want to block who I'm tired of their cat videos or showing me pictures of the food at their restaurants. That's annoying. I block them. I didn't block their speech. I'm just tired of seeing what you're doing. He was hijacking my page to the point, by the way, he said telephone calls, on Facebook, when you tag a person, when you write their name into the content, depending on how you set it up, you can get a ping on your phone to your message, to your email, however you want to set it up, and mine was set up that way. So when the respondent was writing my name, sometimes early in the morning, my phone would ping. I thought it was my girlfriend. I didn't know. And he would sometimes do this 4 or 5 times an hour. That's my phone going off all the time. I had to finally set up a block function on that. So that was constant harassment. All of these other issues, like I said, if they want to raise them, belong in a federal court where the constitutional issues of public figure status and constitutional rights of free speech belong. As you know, in the standing of the municipal court, you're dealing with the issues that you are responsible for, and constitutional issues are not to be brought up in that. They're not for you to determine. That is for a federal court to determine the appropriateness of both public figure standing and constitutional free speech. There's a lot more he said, but really we got to get back to square one, as he suggested, the real facts of the case. He did cyberstalk. You determined that correctly. I appreciate that. It should be permanent. Second, I appreciate the surrender of weapons. That was clearly an appropriate choice, especially given the dishonesty that he showed this court about the weaponry. And that should also continue. There's really not much more to say. This is just a smokescreen. This is just a diversion. And this is just really a waste of this court's time to discuss these issues, which is really not appropriate at this venue.
All right, thank you. Anything further?
Your Honor, I think we've made our position well known.
Okay, thank you. As I said in the beginning, I have had a chance to very thoroughly go through all of the paperwork, and I spent a great deal, many hours, many days, as a matter of fact, taking a look at all of this. And and going through it with a fine-tooth comb, and I have prepared some written findings that I'm going to read, which I think will be helpful for those of you who are here and observers. I won't go through the procedural history in the detail that I've written here, but you can look at that later. It just summarizes basically the steps that have been taken in the case up till today. All right, the court has considered all of the paperwork, all of the arguments, and makes the following findings of fact. Petitioner Clarence Moriwaki resides on Bainbridge Island, Washington. Respondent Richard Lee Rynearson III, aka Richard Lee, and herein referred to as Lee, also lives on Bainbridge Island. And I did make some references throughout my findings as to where I found much of the information, but I'm not going to read those out loud, but they are here in the written findings. Their homes are in close proximity to one another, with Lee living in a neighborhood located behind Moriwaki's and roughly 300 feet away. Mr. Moriwaki is a private citizen, not a publicly elected official. He is a volunteer director of the Bainbridge Island Japanese American Exclusion Memorial Association, a nonprofit organization that oversees a permanent national memorial site on Bainbridge Island and promotes education about the internment of Japanese Americans during World War II. The goal is to prevent any future unlawful detention of U.S. citizens, and the group motto is "Let it not happen again." Moriwaki's LinkedIn page says he's the owner and principal of a private consulting firm, Forest Edge Communications. He applied but was not appointed to Kitsap County Commissioner in 2011 and ran an unsuccessful campaign for Washington State Senate in 1992. He has worked for a variety of governmental agencies over the years, including working for Congressman Jay Inslee and Governor Mike Lowry, but has not been employed by any government organization since 2007. On November 20th, 2016, Moriwaki accepted a friend request on his personal Facebook page entitled Clarence Moriwaki from the respondent using the name of Richard Lee. It appeared the respondent knew of Moriwaki's volunteer work but had not personally met him before when he asked to friend, quote-unquote, friend Moriwaki on Facebook. Lee told Moriwaki, "Clarence, thanks for the ad. I've seen you work with the memorial on the island and I'm grateful." And then in parentheses, seen via YouTube as I've only lived on the island 4 months. Over the next couple months, Lee participated on Moriwaki's personal Facebook page about various lighthearted topics such as a ferry accident, the Winslow Green, where Moriwaki lives, the Boy Scouts, holiday movies, crows, and a few political conversations. On December 14th, 2016, Moriwaki commented, quote, "Nice to meet you in person, Richard Lee," after he came to a movie screening fundraiser for the Memorial Association. Later on the same day, Moriwaki further asked Lee to meet up in person for coffee or beer in a private message via Facebook. They exchanged phone numbers and a few messages, but the two did not find a mutually agreeable time to meet up. Lee first mentioned Obama's support for the National Defense Authorization Act, NDAA, of 2012 on December 14th, and then again on January 1st, January 6th, and January 24th. It was after this fourth mention that Moriwaki stated, quote, "Richard Lee, you've made this point many times, often to the point of hijacking a comment thread. Now where's your pivot?" unquote. And made the suggestion, quote, "Direct it to the person in administration that can do something about it," end quote. Moriwaki also suggested taking it offline for an in-person conversation. Lee suggested numerous days and times to get together, but none worked for Moriwaki. The next day, on January 25th, 2017, Lee wrote a review on the Bainbridge Island Japanese American Exclusion Memorial Facebook page criticizing Moriwaki for supporting Jay Inslee and Obama and for, quote, "censoring non-liberal viewpoints on this page," unquote. On January 27th, 2017, Moriwaki and Lee got into a contentious discussion on Moriwaki's Facebook page, and Moriwaki told him he was offended. On January 29th, 2017, Moriwaki private messaged Lee telling him, quote, "You've crossed a line. You're not conversing but trolling. My Facebook page is like hosting a party. Friends are welcome to comment, but as the host, I have a responsibility to all my guests to try to keep it civil, and if someone at the party keeps butting in, trying to monopolize conversations, I, as the host, have a right to ask them to please cease and desist. You are clearly a passionate person, but please promote your ideas and attract people to your own wall. Create your own party. Stop the bullying and attempts to hijack my party," unquote. Later in the day, on January 29th, Lee posted on Moriwaki's page, quote, Clarence Moriwaki, I think my comment got deleted from your wall, even though it is the same question I've asked over the past several days with no reply from you, unquote. What followed is a lengthy post explaining his concerns with the NDAA of 2012 and demanding Moriwaki to explain why he didn't fight against the law and why he isn't working to support the proposed Senate Bill 5176, which would counteract the provisions of the NDAA. Moriwaki responded to this January 29th, 2017 post via private Facebook message, where Lee responded, quote, it is your right to delete posts from your wall. I get that, but why can't we have a debate about the NDAA or the bill to stop Washington resources from being used to comply with it or such things? I think this is a typo. I wrote opening, but I think it was supposed to be something else on your wall. Moriwaki responded, quote, your post, repost, and this very comment are the definition of trolling, relentless contact that harasses. Along with being insulted and offended, you don't get to define when I feel harassed. On February 4th, 2017, Lee posted a long comment on Moriwaki's page about Obama and Inslee's support of the NDAA and mentioning Moriwaki, stating, quote, just because someone is different than you, Clarence Moriwaki, doesn't make them a, quote, troll or somebody who harasses or a threat or a subversive. Let's celebrate diversity, Clarence. Lee then posted 5 other comments immediately thereafter complaining about Moriwaki not being interested in Lee's point of view. Moriwaki responded in private message telling Lee, you are doing real-time trolling. Can't you control yourself? You are bullying. You are also a bit of a sociopath. Lee responded, Clarence, I'm not trolling or bullying. Now you are about to cross my line. I highly advise you to reconsider. My line is one of diversity and free speech. I promise you with everything that I am, your efforts to stifle free speech will fail you massively. The next day, on February 5th, 2017, Lee sent Moriwaki a private message complaining that his posts had been deleted, saying, quote, so you recognize that you censoring the speech of others who are different from yourself is wrong, but then you repeat it by doing it again the next day. If you censor my viewpoint yet again, you will have crossed my line of diversity and mutual respect. I hope that you don't cross that line. Moriwaki noticed that Lee began reposting any deleted comments by posting screenshot photos back onto Moriwaki's page. Moriwaki responded in private message to Lee, stop trolling, stop it. You are harassing, bullying, and relentless. Stop. Your self-righteous reposting is the definition of harassment. Dude, I am going to report you to Facebook. Knock it off. Then the two then argued back and forth, Moriwaki again repeating, quote, knock it off, all in caps. I have asked you to stop posting on my page. Moriwaki finally stated, we are done. Lee replied, quote, oh, we are not done. What follows next is done with love. You need my help to celebrate diversity. Should you reflect on your behavior and your fear of those who are different, and should you come to celebrate free speech and discourse in the future, let me know, unquote. Moriwaki then blocked Lee from posting on his personal Facebook page. The same day, shortly after blocking Lee, Moriwaki received a text message from Lee stating, quote, Mr. Moriwaki, I'm doing an initial story for a new and upcoming blog, and then in parentheses, ClarenceMoriwakiBainbridgeIsland.com, about your role as president of the memorial and your support for multiple politicians who expressly voted to make internment happen again. Looking forward to your comment for the story if you are interested. Thanks, unquote. Moriwaki responded to the text, quote, yeah, and this isn't trolling and harassment. Richard, your obsession is getting disturbing. Start respecting me by leaving me alone. After being blocked, Lee posted a comment on the Facebook page of Bonnie McBrien, a friend of Moriwaki, stating, quote, I'm outside on the street, in Clarence's analogy, after Clarence put his hand over my mouth and threw me out. So I'm out on the public street now in front of his house talking to some of his guests, quote, our mutual neighbors, or not quote, in parentheses, as they leave his house, some of which appreciated my comments, unquote. Ms. McBrien responded, quote, I am really concerned about your statement that you're outside Clarence Moriwaki's house and talking to his guests and mutual neighbors. I assume that is rhetorical. If not, it sounds a bit threatening. Ms. McBrien then messaged Moriwaki telling him, quote, Richard announced he's outside your house. You might unblock him to take a screenshot and consider calling the police. By February 5th, 2017, Lee had published a public Facebook page entitled Clarence Moriwaki of Bainbridge Island, declaring, quote, "This page is meant to be a discussion concerning our view that public figure Clarence Moriwaki, president of the Bainbridge Island Japanese American Exclusion Memorial, is unfit to be president or board member for our memorial." This page title was later changed to Not Clarence Moriwaki of Bainbridge Island. On the Facebook pages titled Clarence Moriwaki of Bainbridge Island and Not Clarence Moriwaki of Bainbridge Island, there are a variety of memes, many bearing Moriwaki's photo. One has his photo with barbed wire and a message that Moriwaki supports, quote, "politicians who made indefinite detention without charge or trial, quote, legal." Lee posted on the Not Clarence Moriwaki of Bainbridge Island Facebook page almost daily, sometimes numerous times a day, until Lee was served the stalking protection order on March 15th. Lee even posted the private conversation between Lee and Moriwaki where Moriwaki said, "We are done," and Lee said, "Oh, we're not done." Lee paid for advertising of the site, and the ads for the site appeared in feeds of people who did not sign up to see it. Moriwaki's original petition claims he feels constant anxiety, sleeplessness, fear of potential contact, upset over impact to my reputation, intimidated. After discovering more information about Lee on the internet, Moriwaki states he is, quote, "truly frightened for my physical safety and life," from Richard Lee Rynearson III, and that he has had, quote, "far too many stressful, anxious days, sleepless nights, and upsetting nightmares." Numerous people messaged or posted asking Lee to stop harassing Moriwaki through the Facebook page. And these are examples. Gregory Wernhoff, quote, "You slander this man just because he is your neighbor and he does not do as you would have him do." Christine Rolfs, "The name of this page falsely assumes the identity of Clarence. While I don't support your vendetta, I do suggest you rename your page. It may or may not violate identity theft laws." William Bauer, quote, "I'm not sure that Clarence is a public figure in this capacity. He appears to be a private citizen leading a private nonprofit group." Danny Griever defined vendetta for Lee and posted, quote, "an often prolonged series of retaliatory, vengeful, and hostile acts or exchanges of such acts," unquote. Keith Broski posted, "This is really shameful, Rick Rynearson, aka Richard Lee. You're attacking a private person who is respected in the community, who's not an elected official. It strikes me as slanderous and wrong. This is over-the-top judgment and vitriol. Take it down voluntarily, or FB, Facebook, will do it for you." Shannon Evans wrote, quote, "They are a 501c3 nonprofit private organization, and as such they cannot endorse candidates, campaigns, or issues. So all this ranting and going after elected officials is out of bounds," unquote. Bob Garrison, quote, "Having a page devoted to attacking someone seems a bit sketchy. He's a private citizen and not a public figure. Having discussions and disagreements are great, but that doesn't seem to be your goal." Bonnie McBrien, "Richard, it's time to stop commenting on Clarence Moriwaki. Dude, this is not cool or fair. The man you attack is gentle, kind, and patriotic. Please move on to another topic." Lee made the Not Clarence Moriwaki of Bainbridge Island page not public after being served with the stalking protection order. Lee has a documented history of angry, inappropriate, name-calling, aggressive online comments to the point where he has been banned from multiple online discussion forums. Lee also has a history of retaliating against those forum owners who have banned his participation through angry comments, personal attacks, and creating memes to taunt them. Lee admits that he has a car that is outfitted with bulletproof windows, armoring, electrified door handles, a smokescreen camera, flashing strobe sirens, and a public address system. Lee is an admitted gun owner and Second Amendment advocate. He served in the military for many years and eventually resigned after a disagreement over completing a mission. He has a documented history of being disciplined over disagreeable, argumentative behavior. However, none of those disciplinary actions involved violent or threatening behavior or inappropriate use of his firearms. Lee made online comments about the judges that ruled against him in his federal case. Quote, "I have killed many foreign enemies overseas who were far better men than Judges Reevely and Southwick." He also presented a rant comparing the judges to tapeworms who destroy America from the inside out, and stated, quote, "There isn't enough tar or feathers in this world to sufficiently coat these two worthless deserters." However, there were no other direct threats to harm these judges. Lee has no criminal history that the court is aware of. And finally, on the court's findings of fact, the court further incorporates the exhibits filed by the parties of the websites, Facebook pages, and online conversations. There does not appear to be any disputes about the content of these exhibits, and they appear to be correct printed versions of what was contained online. The court's conclusions of law. Bainbridge Island Municipal Court has jurisdiction over this matter pursuant to RCW 792-050, RCW 1014-150, and Bainbridge Island Municipal Court Local Rules 7 and 10. 2, the government has a compelling interest in preventing harassment and stalking. And then I listed some of the findings of the legislature. Under harassment, it says the legislature finds that serious personal harassment through repeated invasions of a person's privacy by acts and words showing a pattern of harassment designed to coerce, intimidate, or humiliate the victim is increasing. The legislature further finds that prevention of such harassment is an important government objective. This chapter is intended to provide victims with speedy and inexpensive method of obtaining civil anti-harassment protection orders, preventing all further unwanted contact between the victim and the perpetrator. And RCW 792-010, it says stalking is a crime that affects 3.4 million people over the age of 18 each week in the United States. Almost half of those victims experience at least one unwanted contact per week. 29% of stalking victims fear that the stalking will never stop. The prevalence of anxiety, insomnia, social dysfunction, and severe depression is much higher among stalking victims than the general population. There are many cases in the state of Washington that have provided that prohibitions against harassing and stalking behavior do not infringe on First Amendment's free speech rights. And I quoted some cases here: State v. Smith, State v. Bradford, State v. Noah, and a federal case, U.S. versus Matusewicz. And particularly in the federal case, it does a good job of explaining that speech that is integral to criminal cyberstalking is not protected. The court finds that the stalking and harassment protection order laws are not unconstitutional as applied to the respondent. The court finds that Lee engaged in a course of conduct directed at Moriwaki, where Lee repeatedly contacted, harassed, stalked, and cyberstalked Moriwaki. The court finds that all of the elements of stalking under RCW 9A46110 and cyberstalking, RCW 961-261B, repeated contacts, and unlawful harassment, RCW 1014-020, have been proven by a preponderance of the evidence. As described in detail in the findings above, Lee repeatedly contacted Moriwaki by posting on his Facebook page after being specifically asked to stop. Lee reposted screenshots that had been deleted by Moriwaki. Lee sent a message implying he was outside Moriwaki's home to Moriwaki's friend. Lee sent a text message to Moriwaki threatening to start a blog about him on a webpage named after Moriwaki. Lee created a public Facebook page bearing a title with Moriwaki's name. Lee created numerous memes with Moriwaki's image without his permission. Lee paid Facebook to advertise the page with Moriwaki's name and image, which then went out to Moriwaki's friends and others that did not seek out the page. The court finds that these acts were done with the intent to harass, embarrass, intimidate, torment, and retaliate after being limited and blocked from Moriwaki's personal Facebook page. The acts were also done to cause damage to Moriwaki's reputation. The court finds that Lee's behavior caused Moriwaki to feel threatened, intimidated, and frightened. Moriwaki has experienced extreme stress, anxiety, and fear that Lee will damage his reputation and continue to stalk him. The court finds that these feelings are reasonable under the circumstances, given the facts, circumstances, and the extremely brief and limited relationship between Lee and Moriwaki. The court finds that Lee has no lawful or free speech purpose in carrying out these actions. Specifically, although I understand that he has couched some of his some of the things that he's done in a sort of free speech defense, I find that he specifically the true purpose of Lee's conduct was to harass, intimidate, torment, and embarrass Moriwaki because he was limited and rejected from his Facebook page on sort of a friend level, sort of the rejection. and that he did so. The other thing that I didn't write in here is that the nature and time of the time when he decided to carry out this Facebook page was so close to being blocked that it showed me that he really was hyper-focused on getting back at him and for not being willing to have a discussion with him, and that really was the purpose. It's also significant to the court that there are many other directors and volunteers of this organization as listed in the 501c3 paperwork that was in here, and not one of those people was ever mentioned. That this was really a personal thing against Mr. Moriwaki because he did not reciprocate his interest in developing a friendship and having the kind of relationship that they were going to have on his Facebook page, according to what Mr. Rynearson wanted to do. So I reject the claim that these actions cannot be prohibited under the First Amendment right of free speech. There's an interchange where if you have conduct that, there's speech involved with the conduct that's being carried out, and that conduct has been limited by the state of Washington as harassment and stalking, then you don't get to just say, well, I spoke, therefore I have a free speech right. The state of Washington and the court has a right to limit these actions when they fall into this course of conduct of being harassing, which the court specifically finds they were. I reject the claim that they have a right to attack him as a public figure. He is not an elected official, and in his volunteer role, it has not rendered him a limited purpose public official. He has no right to forcibly converse with Moriwaki on his Facebook page, and Moriwaki has the right to limit the contact with any person who he finds offensive. As I stated, the court finds that the true purpose of his conduct is to harass, intimidate, torment, and embarrass Moriwaki and cause harm to his community reputation. And the court finds that Lee began these actions as retaliation after being limited, rejected, and eventually blocked from Moriwaki's personal site. Lee knew or should have reasonably known that his behavior intimidated, frightened, or threatened Moriwaki due to Moriwaki's request to stop, as well as the attempts of numerous community members to get him to stop. Because the court finds that Lee has stalked Moriwaki by repeatedly contacting, stalking, cyberstalking, and harassing Moriwaki, it is reasonable to place limits on his conduct and contact towards Moriwaki, as I will outline in the court's protection order. The court finds that Lee is likely to continue acts of harassment and cyberstalking upon the expiration of a 1-year order, and that a permanent stalking protection order is appropriate. This is based on Lee's refusal to stop his online harassment of Moriwaki after being told to stop, his stated intent to continue his harassment via a website in Moriwaki's name after being blocked, and his prior harassing behavior of various online forums that resulted in him being banned, his prior retaliatory behavior towards another individual who banned him online, and the petitioner filed an additional newspaper article today that indicated he desired to continue his online criticism of Mr. Moriwaki if he could get the court's order overturned, which additionally supports his request. Pursuant to RCW's 941-800, subsection 5, this court must find that possession of a firearm or dangerous weapon presents a serious and imminent threat to public health and safety or the public health and safety of Mr. Moriwaki. The petitioner has informed the court that he is fearful of his safety and life due to the harassment by Lee and that the information he discovered online about him. However, the petitioner has not proven by a preponderance of the evidence that the respondent presents a serious and imminent threat to public health and safety or Moriwaki's health and safety by his possession of a firearm. Although the respondent has engaged in cyberstalking and harassing conduct towards the petitioner, there must be more threatening, violent, or assaultive behavior for the court to remove the respondent's firearms. The respondent has no criminal history and has not made any threats implying physical violence towards Mr. Moriwaki. Further, this court cannot find any incidents of threats or violence in his past. The court cannot find that his mere possession of an armored car, prior military reprimands, and prior argumentative, obnoxious, and harassing online behavior are sufficient to prove his firearm possession poses a serious and imminent threat. I considered this very carefully, and I want everybody to know that. I really read through every single thing that was filed in this court. And the court certainly finds that Mr. Rynearson is very irresponsible with a lot of his speech and doesn't really care all that much about how he makes people feel or the damage that it causes people through his actions, but that he has not done anything that puts the court in a place where there is a preponderance of the evidence demonstrating that he's going to use his firearms to harm the petitioner. And so therefore I cannot grant the request of the petitioner to require him to further leave his firearms surrendered. And so those, assuming there are no other reasons to withhold them from him after law enforcement does a background check, will be returned to him. I'm going to go through the terms of the court's order. The court, as I said before, is issuing a non-expiring order. There is to be no contact directly or through third parties with the petitioner. You are prohibited from keeping him under surveillance, including electronic surveillance. You are excluded from his residence and workplace. You are to stay away from his place 300 feet from his residence or workplace. The respondent is restrained from knowingly appearing at any public events petitioner appears at. It is the respondent's duty to leave should the parties inadvertently appear at the same location. These stay-away provisions do not prevent the respondent from using his real property on Shepherd Way, including the driveway, garage, and common areas of his condo complex. So should there be an inadvertent, few feet that go into that complex, this court's order has made it clear that that was not intended to prevent him from using it and would not be a violation of this order. The respondent is prohibited from creating or maintaining internet websites, Facebook pages, blogs, forums, or other online entities that use the name or personal identifying information of the petitioner in the title or domain name. The respondent may not use the photograph of the petitioner to create memes, posters, or other online uses. So, as you may wonder, I'm not specifically issuing an order that prevents him from potential online discussion. However, this is the court's order. I'm not going to advise you what's allowed to say or not allowed to say, but you need to stay within the confines of this order. I specifically find that creating a Facebook page or web page that has his name on it is not about discussion. It is about targeting and harassing him, and that's why the court is going to prevent you from doing that. I also find he's not a public figure, and you don't get to use his picture, personal identifying information, in things that you want to create because you have a history of harassing him. So that's the reason for the court's order. Any questions?
Yes, Your Honor. There's also an easement connected to my client's property, which is, he owns his property and there's an easement connected to it. And so does this...
What's the easement?
There's an easement that goes from his property down to the main street of below. There's a pathway, from what I understand.
And it takes him to what street?
I believe it's Winslow Way, Your Honor.
Main Street.
I can speak. Your Honor?
Well, that's probably putting you within the 300-foot
And that's why I was asking for clarification, because the court was allowing usage of his property, and so the easement is part of his own property, being able to use it to the full extent. And that's why we were asking regarding...
And so it's a pathway that leads from Shepherd Way down to Winslow Way, but you believe but then where would he go? Because once he started walking down Winslow Way, he would be heading into that 300-foot area.
Well, I believe he can go two different directions in Winslow Way, right? So he doesn't necessarily have to go the direction towards the petitioner's home.
Okay.
Wait. May I speak to that?
Yeah.
That easement goes right next to the parking lot within 60 feet of my apartment.
Mm-hmm.
So that has to be blocked. I mean, if he walks by, he's clearly next to my property.
Well, then the exception will be the easement, and you can litigate that as you go up, I guess. Because
Your Honor, I have strong objection to that, because That
So-
takes away the 300-foot.
No, I'm ruling in your favor.
Okay, and I
Okay,
didn't
and I wasn't
understand you.
clear, but,
Right.
Your Honor, did the court conclude? I didn't hear any conclusion regarding the allegation of physical stalking.
would you like to point me out to where I have to find that there's physical stalking?
No, I'm simply asking because there was allegations as to both cyber stalking and also physical stalking regarding the respondent showing up to the.
I'm not making a specific finding as to whether he did that or he didn't. I think that he implied that it was a possibility that he may or may not do that, but I don't find that he necessarily did do that. I don't think that I have to find that he actually physically was in front of his house in order to grant this order. There's nothing in the elements that require that. All right, so... And I'm not finding whether there was an easement or there isn't. There's a claimed easement. I don't know if there is or there isn't, but I'm just writing in here to be clear, the respondent may not use the pathway that travels from his condo to Winslow Way. And then I'll put next to Winslow Green. All right, so Diane is going to make copies of all of this for you. I think we may need some signatures on the orders. They don't have to sign that one, but the other one does, yeah. All right, any other questions?
No, thank you, Your Honor.
All right. So court will be in recess. Officer Roach has some papers to have you sign. We will receive copies. I would direct everybody not to stay here to socialize or mill around. The officer, if you'd like to leave first, he can allow you to do so, or direct the other party to leave first.
They can leave first.
Okay. All right.
Court's at recess.